Good morning, ladies and gentlemen of the Queensland Law Society. I'm from Lawyers Associated and have been requested to investigate the current legislation regarding unsociable conduct and present it to those of you here today. Firstly, I'll be explaining the current legislation and issues, as well as outlining some legal terms which may be relevant to this presentation. Secondly, through the use of precedent cases, I'll explain and evaluate the current system, as well as provide suggestions for possible improvements. Thirdly, I'll provide a conclusion and my recommendation based on the findings of this investigation. Essentially, there are two main elements to unsociable conduct. The first being that one party to an agreement is at a legal disadvantage. This could be anyone ranging from an illiterate old man to a disabled young schoolgirl. The second element is that one party takes advantage of the other party's disadvantage. Alright, so the legislation relating to unsociable conduct can be found in the Australian Consumer Act, the ACA, sections 20, 21 and 22. Decisions made in court are also largely dependent on common law from precedent cases. Section 22 of the ACA determines which party is privileged and which is marginalised, if any, which is the main issue with unsociable conduct. The first precedent case we'll be looking at today is ACCC versus Lux Distributors. To put this into perspective, the ACCC are the Australian Competition and Consumer Commission, and Lux Distributors are a door-to-door vacuum cleaner sales company. Between 2009 and 2011, Lux Distributors engaged in unsociable conduct by going to the houses of elderly women under the premise of a free vacuum cleaner check, where women were subjected to unfair and pressuring sales tactics to induce them into purchasing new vacuum cleaners or services for up to $2,280. This case relates to 3 customers. Initially, the case was won by Lux Distributors. However, when the case was appealed in a full federal court on August 29, 2013, the ACCC plea was upheld. Lux was found to have breached Section 21 of the Australian Consumer Law. The section states that a person must not, in trade or commerce, engage in conduct that is unsociable within the meaning of the unwritten law. In this case, Lux was the privileged party, which took an unfair advantage of the 3 elderly women, who were at a disadvantage. The elderly women were disadvantaged because of both their age and the fact that they were caught unawares by Lux Distributors, who gained entry to their home under the pretext of a free maintenance check, when the actual objective was trying to sell a completely new product. A possible way to improve the speed of this decision would be to introduce new sections to the ACA which outline ways to clearly differentiate the privileged and marginalised parties. However, this would be very inconsistent as no 2 situations are the same. The time factor, which is involved when there is any new legislation introduced, must also be taken into account, and in the end, this change wouldn't really be an improvement on the current legislation. All in all, this case shows that the current law is working and fair, both from Section 21 of the ACA, as well as the appeal process found in the judicial system. The second precedent case we'll be discussing involves a prenuptial agreement where the millionaire husband took his wife to court, accusing her of unsociable conduct. 58-year-old Sydney millionaire met his wife, who was 14 years younger than him, in a strip club in 1998. They lived together until 2005 when they eventually married. When they separated in 2007, the wife requested that her husband uphold a prenuptial agreement worth $3.25 million. Since separation in 2007, she has been living with a truck driver de facto on a wage of $411 a week, with no qualifications, having left school before grade 10. The husband claimed that he was a victim of fraud and that his wife was a gold digger who used frequent high-quality sex to lure him into a loveless and childless marriage. In court, however, the husband failed to prove that he was a victim of fraud, and it was also revealed that it was the husband's idea to have the prenup in the first place. The family court ruled that the wife had not done him unfairly or unsociably, and was ordered to uphold the $3.25 million agreement. The husband was unsuccessful in claiming unsociable conduct because he was unable to prove Section 22 of the ACA, in that he was the marginalised party or that his wife was privileged, due to it being him that had originally suggested the prenup agreement, as well as proposing marriage to her, and not it being the other way around. The law in this case is working adequately in that he brought his problems upon himself, and the woman did not seek him out just in order for his money. Although the current law is adequate in providing solutions for issues relating to unsociable conduct, as well as balancing the needs of society, it does nothing to promote awareness or prevention. A solution to this would be new legislation drafted for all cases involving agreements of over $5,000. The law would state that both parties must first consult lawyers privately. The lawyers must explain all the different terms and conditions to their clients. After the meeting, the lawyers would be required to sign off to make sure there be no unsociable conduct from either party. In the business and personal lending section of the National Australia Bank, to decrease liability when associating with guarantor customers, this system is already in its use and is effective in minimising the risks associated with unsociable conduct. This change would almost entirely remove issues of unsociable conduct throughout society. However, it would be very expensive and time-consuming. To negate these cost issues, the government could provide lawyers specifically for cases like this free of charge, but again, while providing fairer outcomes, this would be very time-consuming and cost-inefficient. And that concludes our presentation. Now back over to Josh for any questions you may have, as well as a brief discussion on the recommendation and conclusion.